This case is also based on the doctrine of notice and particularly on the doctrine of actual possession as constructive notice. So, if someone is having actual possession of the property, it is regarded as a constructive notice to the other parties. सो इस केस के जो बेसिक फैक्ट्स हैं वो ये हैं कि डिफेंडेंट 1 और 2 जो कि सन और मदर हैं, उन्होंने उन्होंने एग्जिबिट P2 जो कि सेल डीड था उसके थ्रू प्रॉपर्टी रिस्पोंडेंट को सेल करी एंड द रिस्पोंडेंट वॉज इन एक्चुअल पोजिशन ऑफ द प्रॉपर्टी. सो द पोजिशन ऑफ द प्रॉपर्टी वॉज विद द प्लेंटिफ हु इज Deveeramma. In the case, the respondent Deveeramma was in the actual possession of the property, and via exhibit P2, the sale deed, defendant 1 and 2 sold the property. Then, via exhibit P3, the defendant 1 and 2 got an agreement of reconveyance from the plaintiff Deveeramma. However, there was an earlier existing exhibit P1 which was sale of right of reconveyance, that was release deed. So in these facts, the issue that raised was whether defendant 3, the appellant who is Narayanaswamy, whether he was a bona fide buyer or not, and whether he was entitled to get reconveyance from defendant 1 and 2. So bona fide buyer basically means someone who has paid the consideration and he has not notice of the fact. So what the court observed कि a person is said to have notice when either उसे actually पता हो और he has willfully abstained from making any inquiry, or he was negligent to inquire, or else if he had made inquiry he could have got the information. So what the court said कि in the facts of the present case, any average prudent person would go and inquire about the property as the plaintiff Deveeramma was having the actual possession of the property. So if someone is having actual possession of the property, it is deemed to be a constructive notice. So the court rightly observed that as the plaintiff Deveeramma was having the actual possession of the property, it will act as a constructive notice to Mr. Narayanaswamy. And in the facts of this case, Mr. Narayanaswamy willfully abstained from making any inquiry. So he willfully neglected and willfully abstained from making any inquiry about the property and about the possession. So it was held that since plaintiff was with the actual possession and it was a duty on the defendant 3, that is Mr. Narayanaswamy, to inquire with the plaintiff about the rights, as he did not inquired and he was not willing to inquire and he willfully abstained from making an inquiry about the nature of the possession and the nature of the right that plaintiff was having. The court said it was a case of constructive notice and hence he was having constructive notice of the fact due to the possession that was with the plaintiff.